Thank you very much, Mr Chair. Mr Chair, I want to lift this up a little bit and start from a sort of fairly basic kind of premise, and that is what are we talking about when we talk about parliamentary privilege? Because I think a lot of people listening in at home or watching this on TV, when they think about parliamentary privilege, they will think about accommodation, airfares, what might otherwise be described as perks. Actually, parliamentary privilege in this sense that we're talking about it now has nothing to do with any of those things. So I want to reassure the public that we're not pulling a swifty right before an election and making any changes to those things. Parliamentary privilege in this sense is really about the ability of members of parliament when they are here in this debating chamber, when they are in select committees, to undertake the functions that the public of New Zealand elect us to do. And one of the most important rights that we have through that is freedom of speech, because we cannot actually do the job that New Zealanders elect us to do if we aren't, if our right to free speech isn't protected. And this bill certainly lends itself to protecting that right, and that is a very important one. Freedom of speech means that parliamentarians can come to this debating chamber and speak on any number of issues. They can champion any number of causes with a degree of certainty that they're not suddenly going to find themselves up before the courts, for example. Now, I want to deal particularly with a challenge that's been laid down to members of parliament recently in the media around name suppression, and I don't intend to do what Rodney Hyde wants members of parliament to do, but I do want to talk about the issue, the principle of the issue at stake here, and that is that if a member of parliament comes to the House and breaches a name suppression order issued by the court, they wouldn't find themselves up in front of a court for breaching name suppression, but they would find themselves up in front of Parliament's Privileges Committee, because while the parliamentary privilege would afford us some protection in terms of the court's rules, privilege itself comes with a whole lot of rules around it as well, and protections around it as well. And so this is not about saying that members of parliament are above the law, or that there should be, that we should be able to get away with anything. In fact, what it says is that parliament itself should be the administrator of rules around parliamentary privilege, and all members of parliament at the end of the day are accountable to their colleagues in the House, the other elected members of the House, for the way they conduct themselves as members of parliament, and that is the way it should be. It shouldn't be that we establish the laws here in the Parliament of New Zealand, and it shouldn't be that we, and in the process of doing so, that we find ourselves in front of the courts basically having to justify what we have done or what we have said. Actually, Parliament is supreme in New Zealand, and should be, and the members of the New Zealand public elect us to do a job, and we need to have the certainty to be able to go ahead and do that without the risk that we're going to find ourselves before the courts. One of the issues that I want to talk about, particularly because I have been on this side of the fence, is the protection that this bill provides to officials advising ministers. Because here in Parliament, one of our jobs as members of Parliament is to hold the government to account, and from time to time that can be challenging. It can be very challenging for the government, and that we will sometimes stretch the boundaries a little bit as the opposition, and that is actually the role of the opposition. But ministers need to be well prepared to be able to cope with that and to be able to answer whatever gets flung at them. That means they need to be able to rely on free and frank advice from their officials, and if their officials won't provide them with that advice on the basis that doing so could result in that official themselves landing up in court, then the very free exchange that we have here, that we rely on as part of our democratic process, becomes compromised. Because if an official is sitting briefing a minister and they know some information that may be defamatory or that may be questionable, and they're thinking, if I say this to the minister, then I potentially could end up in court, they won't say it. And actually the minister needs to know that, because in order for that exchange to take place, it needs to have, both sides need to be able to have access to the information and need to be able to rely on that free and frank exchange. So this bill extends privilege to those providing, a certain range of privilege to those who are providing advice to ministers. That's vitally important, because at the end of the day, I don't think anyone in the Parliament, no matter whether you're on this side or that side or over there, wants a minister to come to the House not sufficiently informed to be able to answer the questions that other members want to put to them. I think that we all want that to happen, and so this bill certainly deals with an issue that has come up previously. So Mr Chair, Mr. Chair. Just in concluding, the final point that I want to highlight from this is around the inability of members of Parliament under, I guess, current arrangements to do anything outside the House that in any way even acknowledges something that they have said inside the House. We've seen situations where members of Parliament have said something in the House, they've walked out of the House and they've been stopped by a journalist or whatever, and they've just had this blank expression on their face and they haven't been able to say anything at all. Because even simply saying, I stand by what I said in the House, or I'm not going to add anything to what I said in the House, suddenly finds them potentially up before the courts. That's not right. And it undermines the integrity of the Parliament, it undermines the public credibility of the Parliament. So if they went out and repeated in the public exactly what they'd said in the House, then sure, they should find themselves before the court, because they would be doing that at an open place where they're not protected by privilege. But simply saying, look, I'm not adding anything to what I've said in the House, or I stand by what I've said in the House, that's a perfectly legitimate thing for a Member of Parliament to do. It means that it actually, if anything, draws a very clear line between what they're doing in Parliament and what they're doing outside of Parliament. And so I think that the clarifications made in this bill are very important. So I guess the final point that I would make is I conclude this contribution. Finally, and in conclusion, I conclude where I began, which is for the public. When we talk about privilege, we're not talking about the things that members of the public will think about when they think of the privilege, role of parliamentarians. It's nothing to do with what the public might describe as perks. This is all about us being able to undertake our duty as legislators and as members of Parliament, and holding the executive to account without that fear that we'll find ourselves in front of the courts.
Mr. Chairman.
The Honourable Christopher Finlayson.
In conclusion, Mr. Chair, can I endorse what other members have generously said and thank